Good afternoon. You can be seated. The matter before the court is Newsom versus Town of Kittery et al. This is York 24-478. We are being streamed by video and audio on the web. If counsel who will be arguing would introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good afternoon, Your Honor. Zach Brandwein for Appellant David Newson.
Good afternoon, Gordon Smith for Appellee or Party in Interest, IDC 5.
Good afternoon, Cameron Ferrante for Appellee Town of Kittery.
Thank you. And Attorney Brandwein, if you're ready to proceed, we'd be happy to hear your argument this afternoon.
Good afternoon, Your Honors. I've waived my reserved uninterrupted time. I'm happy to answer any of the court's questions.
All righty, let's get started.
Justice Connors.
The bylaws, section 11, say that the time for the public input is at the public hearing, with written submissions prior to that date. Mr. Newsom did nothing at that public hearing and submitted nothing. So if due process gives you notice and an opportunity to be heard, he had a notice and an opportunity to be heard, so how is there a due process violation here?
Your Honor, I think you're referring to sort of the second part of our argument that the board's procedure after March 28th on April 11th was insufficient from a substantive due process standpoint.
Are you making a substantive due process argument?
Excuse me, a procedural due process argument. Thank you, Your Honor. Our argument there, Your Honor, is that even if Section 17 of the bylaws did not apply to the board's actions, which obviously we believe that it should have, and it did, and the board should have followed Section 17, but even if it didn't, the board was still obligated to provide some procedural safeguards and guardrails to ensure that there was adequate public hearing, notice, and process when it revisited the question about the extension of the zoning boundary line extension and the site plan. The site plan issue was not reached on March 28th. It was only reached when the board revisited or reopened, reconsidered, in our opinion, the issue on April 11th. At that point, Town of Wiscasset, the Board of Environmental Protection, and other cases stand for the proposition that the planning board was obligated to provide some procedural guardrails to ensure that once it revisited this question, it was able to receive input from the public was properly noticed. And I would also point out
But
that
aren't you just, you're answering the question by changing the ground. I mean, the question is really, what was the second hearing? I mean, you're saying they revisit, they reconsider, they this. Isn't that the issue? I mean, their position is that they didn't. This is...
The issue is that they reconsidered and should have followed, they reconsidered the March 28th vote on April 11th and should have followed Section 17 of the bylaws when they
If it wasn't a reconsideration, is there a due process violation?
There is. That's the question I was trying to answer for Justice Connors. There is still a procedural due process violation, even if Section 17 didn't apply, because the board didn't provide adequate procedure on April 11th or prior to April 11th to ensure that interested parties had notice, opportunity to comment.
You got all the notice under the bylaws and the ordinance, correct?
Well, again, Your Honor.
Are you saying they're inadequate? That the ordinance, there's something deficient in the ordinance?
What I'm saying is, first of all, Section 17 should have applied to the board's actions. That would have provided sufficient procedural protections. The board didn't follow Section 17. Obviously, again, our position is Section 17 should have applied. Even if you find that Section 17 did not apply, you then have to ask yourself, what was the procedure that the board employed to ensure that the public had adequate notice and opportunity to be heard?
At the meeting on March 28th, they continued it to the next available meeting.
They continued it. They didn't notice that they were going to revisit it or reopen it or reconsider it. And on April 11th, if the question before the board was, are we going to reconsider or revisit this issue? And they decided to reconsider or revisit the site plan and the boundary line extension.
But on March 28th, they didn't vote on the site plan. They only voted.
That's correct.
We can talk about what the consequence is, but they only voted on the zoning boundary line extension. They had not yet reached the site plan.
Your Honor is making my point, absolutely. The zoning boundary line extension was a precedential condition to approval of the site plan. The site plan was premised on the C3 zone being extended to cover the entire property.
Did they reach the boundary line issue on the 28th?
They did, and they voted it down. That was a denial on
How
March
did
28th.
they vote it down? You need 4 votes to
You need,
have a valid vote, right?
well, you need 4 votes for a decision. A decision described in the code, section 16.2.2B2, says that 4 like votes are required for substantive, non-procedural decisions. That word decision in section 16.
Isn't a zoning change a substantive, non-procedural decision?
It is. That word decision in section 16 describes a type of vote. It doesn't describe an outcome. Section 16, 4 like votes required for approval of the zoning boundary line extension. The vote on March 28th was 3 in favor, 1 opposed, and 1 abstaining. The motion failed. There's no dispute in the record that the motion on March 28th to extend the C3 zone failed. Our position, and I think this is supported by the code and plain text interpretation of section 16 and section 17 of the bylaws, is that's a final decision. That's appealable, and if the board wished to reconsider that decision, it needed to follow section 17 of the bylaws, which provides adequate process for reconsideration.
If we don't agree with your conclusion that that was a decision that could be appealed, if we don't buy into that, do the rest of the dominoes fall after that?
I'm not sure I follow Your Honor's question.
Well, at the March 28th meeting, a vote was taken. It wasn't sufficient under the rules. Board chair says, didn't pass. In other words, nothing happened. Is that an appealable decision?
That's incorrect. Something did happen. There
What?
was a vote.
There was a vote?
Under section 17 of the bylaws.
And if we
a vote was
disagree
passed.
with you,
Yes.
that that's a final decision on the zoning boundary, as opposed to the motion today did not pass, but we still don't have a final decision, do the rest of the dominoes fall as well?
There is still inadequate procedure if you disagree with our argument that section 17 of the bylaws should have applied. Because on April 11th, there was no discussion about why the board was revisiting this. There was not, Mr. Newsom's letter and objection was not included in the record.
But I thought, just not to interrupt you, but I thought at the April 11 meeting, it started off with the board saying, okay, we don't need to review the project anymore, let's just go ahead and vote.
I think that's incorrect. Mr. Newsom's March 27th letter was included in the board packet on March 28th.
And all that March 27th letter basically said is give us more time to submit information.
Because I'm concerned about traffic impacts on my
understand.
property, I've retained a
Public
reputable
hearing was
engineering
over
firm.
at that point.
Your Honor, the board very well could have said, look, we've received an objection, a concern from the abutter. We're going to reopen this. We're
Did
going to
it have
allow.
any obligation to, once the public hearing and the time for submitting comment was complete?
They might not have, but the harm here is not the outcome. The harm is the denial of the right
Well,
to be
wait,
heard.
let's talk about harm. How is your client harmed in this case?
The
What would have happened differently? Your client didn't submit anything other than this letter saying, oh, give you more time to submit something. And frankly, as far as I can see, didn't even attend, certainly wasn't heard or try to be heard at any of these meetings.
Well, Your Honor, I disagree that that's what the letter said. The letter said, I retained an engineering firm on my own dime to do a peer review
Where
of the
was the
traffic
study?
impacts.
If he was so concerned, why didn't he submit the study and say it violates an ordinance provision? He never said you don't meet the criteria.
Well, that was the request in the letter was, I retained this firm. I'd like to submit a peer-reviewed study.
Why didn't he do it way back when the public was supposed to be submitting its writings?
Your Honor, I can't answer that. What I can answer is,
Well, that's a
regardless of
problem,
what-
isn't it?
I don't believe so. The denial of the right to be heard.
The denial of the right to be heard is harmless if there's no error.
I fervently disagree, Your Honor.
No
The
harm.
denial of the right to be heard is the prejudice. That the denial of.
But he had an opportunity to be heard back at the time of the public hearing, which he chose not to go to. He forewent that.
That's correct, Your Honor, but on March 28th, he submitted this letter. The board voted down the zoning boundary line extension, so it never reached a vote on the site plan. It never went through the criteria
Right.
for site plan approval on March 28th.
So it was still pending,
So it's still pending.
it wasn't being reconsidered because it wasn't voted on.
That's correct. The zoning boundary line extension is voted down. They never reached the criteria of the site plan. On April 11th, they approved both the zoning boundary line extension and the site plan in one motion, without explaining why they've revisited this vote, without including Mr. Newsom's letter in the packet.
Again, where is your client prejudiced?
The
What would
denial
ha-
of-
how would it not have been granted? What criteria was not being met? You never, in this appeal to us, explain how the criteria are not being met.
Your Honor, first of all, I don't think that's required for standing or for cognizable appeal. In Gorham v. Town of Cape
It
Elizabeth.
may not be required to file the appeal, but isn't it required to win the appeal?
Yes, Your Honor. And again, the prejudice here is denial of the right to be heard. It's the denial of procedural due process, which, by failing to include Mr. Newsome's letter in the April 11th packet.
It was submitted in the previous packet.
But they didn't reach the site plan or traffic considerations on March 28th.
And why is that relevant? Because all of the record is open to all of the board members.
The letter appears the first time, and I admit this, the letter appears the first time. He's first submitted it before the March 28th meeting. If the board didn't reach that issue on March 28th, there's no reason for us to believe or evidence that they considered his letter when they.
We are supposed to presume that the board members act in a constitutional manner and meet all due process and the requirements of their ordinance, aren't we?
Yes, but again, they never reached the site plan. The issue on March 28th was that they voted down the boundary line extension.
But so what
that
that
should have
they
been the
didn't
end of
meet
it.
the site, they did in the next meeting, and it was continued over into the April meeting. So, and the time for public participation was done. So again, how is there prejudice?
Again, Your Honor, this court's own precedent in Duffy v. Town of Berwick, Lane Construction Court v. Town of Washington, very clearly stands for the proposition that any interested party, particularly abutters and particularly abutter project opponents, have a right to be heard.
I don't understand why you're saying the extension was voted down. It wasn't voted on. The vote, there was not a vote.
It was a vote, Your Honor. Under
But
Section
it
17
was
of the
not,
bylaws.
there was no decision either to approve or deny it.
I completely disagree, Your Honor. Decision under
And
Code
does it
Section
turn
16.
on that, though? I mean,
It
that's
does.
what we were kind of, so if we disagree with you, if we say, no, it needs 4 to say no, just like it needs 4 to say yes, case over for you?
No, I think you still go to the question about whether there was sufficient substantive, procedural due process on April 11th.
And prejudice or lack thereof?
And there's definitely prejudice because there's a denial of a right to be heard. There is absence of sufficient procedure to
How was he
protect
denied
interested
the right
parties.
to be heard? Couldn't he have, he had the opportunity to put in information at the public hearing. He could have attended the April 11 hearing.
Under the town code, under the bylaws, after the March 28th vote to deny the boundary line extension, it's perfectly reasonable and in fact, I think absolutely appropriate to believe that the issue is dead because the zoning boundary line extension didn't pass. There was a vote on March 28th.
Thank you.
Thank you.
Attorney Smith?
Thank you. Good afternoon. May it please the court. Just to respond to some of what we just heard, when Attorney Brandwine said that the boundary line extension request was a precedential condition for the approval of the site plan, that's inaccurate. The boundary line extension request was to change 5% of the property to the same zone as the other 95% of the property so that the landscaping plan would be consistent and you wouldn't have a 5% chunk that was subject to a different landscaping plan. The project couldn't go forward and comply with the site plan review without the boundary line extension being granted. So as the court has said, I mean, on case after case after case, what the board has done when it looks at questions of due process is look at the proceeding as a whole, not at individual meetings, not at individual notices or opportunities, but overall, did the opponent have a notice and opportunity to be heard? And in Crispin v. Scarborough, Bryant v. Wiscasset, Cunningham v. Kittery, and many others, the court found that even if there were technical violations, which in this case I don't think there were, where the overall process, as the court has noted, provided adequate opportunity and notice to be heard, or opportunity to be heard, the court finds there's no harm. And I would just note that on at least 2 occasions, the court has actually imposed sanctions on appellants where appeals have been brought, and this is in Anderson versus New England Herald and Jackson versus Kennebunkport, the court actually imposed sanctions on appellants where they brought procedural arguments, but did not identify any prejudice and did not even allege any substantive failure of the project to comply with the permitting standards, which is what we see here. There's no allegation that the substantive permitting standards for the site plan review have not been met. That's not even in the appeal. And as the court noted, no harm, no procedural harm, no prejudice has been suffered by the appellant because he could have appeared at any of these meetings, had all the notice that was required under the bylaws, under the ordinance, and simply chose not to. With that, I'll take questions.
I have a kind of a technical Robert's Rules kind of question. Under the way that this works with the language, when a vote is passed and all decisions have to be made for 4. Let's say someone makes a motion to approve a plan. 7 of them are there. 2 people vote to approve the plan, 5 say no. Is that like in limbo until somebody then moves for a denial of the plan, and you get more 4 votes for that, and that's when the vote is passed? Do you need both those?
First, I would say that's a hypothetical.
I
That is
understand.
that's not in front of the court right now.
I
We're here, we had a
understand.
3-1-1 vote, so
Yeah,
every
right.
vote was a majority
I
in favor
get
of
it,
approval.
yes.
And then we had a 5-2 vote. But in the case that you're talking about, I think the practice would be that the applicant could request, either request or the board could on their own, issue a decision saying, we took a vote and we failed to meet 4 like votes, and as a result, we've deemed that the project, that this motion has been denied or the
Because I've
application.
seen it done
Yes.
in that 2 ways, where the motion doesn't pass, and then somebody does the reversal.
Yes.
And I've wondered what happens if they don't.
Well, in this case, I mean, as the court pointed out, what it says is 4 votes for any decision. So that's a decision to deny, a decision to approve, and so there was no decision on March 28th. But, and often we'll see that as a tie vote, where even if you don't have this 4-vote decision minimum, you'll still get a tie vote. And what does that mean? That's, you don't have a majority, so that's a presumptive denial. But that can be addressed in practice.
Does it have to be reconsidered, or does it, or is it, would you have to have it be a final vote? In other words, here, we want a boundary line extension, it doesn't pass. If somebody, then, do they have to make a motion? Let's assume there was a majority that didn't want it to pass, but not 4. Would somebody have to then make a motion to say, all right, we want it not to have the boundary, and then that passes? I mean, is that what you have to do?
Again, those are not the facts in front of us, but
They aren't, but but his arguing that essentially this motion didn't pass, and that is essentially a final decision at that point, even despite what the ordinance says about
Right.
needing 4 votes.
well, the counterpoint to that is that under the appellant's view or the appellant's argument about what should happen, that single vote on a subsidiary issue, a single no vote on a motion on a subsidiary issue, should enable that single board member to withhold their vote for reconsideration. And therefore, the entire project would be tanked, because that one
Well,
person
I thought
didn't.
you said, we're saying this wasn't the entire project, it was just a boundary.
No, but it would result in the entire project. That's what the appellant is saying, is that unless you go back and have a majority, or that one no vote agree to reconsider the decision, then the board can't go forward, because
Well,
that's
let's assume they never did anything else that day, okay? They just said, oh, motion failed to pass, 3-1-1. Is that appealable to the Superior Court? There's no plan, there was no motion to consider, to continue to the next available.
I think it would be appealable if the board issued a written decision explaining the substance of the vote, and in fact, the board memorialized in writing that it was deeming that to be a denial.
Okay, so that, it would have to deem it to be.
You would need something in addition to this 3-1, or anything less than 4 votes doesn't constitute an action that would be appealable.
So was the April 11 meeting, was that a reconsideration of anything, or was that a standalone decision by the board?
That was a standalone decision for 2 reasons. One, That, as the court said, that was the very first time on April 11 where the board voted on any of the substantive standards, voted to approve the project as a whole, the application as a whole. So there's no conceivable argument that that portion of the planning board's vote to approve the project and find it met the performance standards was subject to
Can I ask you
reconsideration.
a factual question about this issue of the precondition? I know you argue that the boundary agreement or extension was not a precondition, but would the site plan have needed to have been revised if that request had not been acted on?
Yes, a minimal revision that I imagine could have been potentially approved by staff, but
So
yes.
it was in effect a precondition, at least the site plan as drafted.
That's correct.
Thank you.
Thank you very much.
Attorney Ferrante?
Good afternoon. I guess I'll take your questions now, if you have any. Otherwise, I can just start talking. So, I mean, I think as the court has heard, this is really just a question about whether a minor procedural issue involving a subsidiary motion can ultimately block or, deny, result in the
Well,
denial
I'll
of this
jump
entire
in
project.
actually then
Sure.
with the same question that I asked Attorney Smith. If they hadn't said, oh, let's continue review to the next meeting, right? And all they did was have this vote that was 3-1-1 on the zoning change. Is that a final appealable decision?
So again.
Motion failed to pass.
Again, understanding that's a hypothetical, and, as a municipal attorney, the general guidance would always be to wrap something up like that with a final motion and vote on appeal or denial, rather than leaving it hanging in that sort of procedural limbo. So functionally, the situation, the circumstances in which that would actually occur are very limited, and that would be the same way you'd address something like the 2-5 vote, where, was stated as a positive motion, as motions should be, to approve a project, but received 5 votes against. So the question then would be, okay, let's clarify this for purposes of written findings, for purposes of the applicant to enable something like a final appeal.
But if
So
if that didn't happen, what's your view? Is that an appealable event?
if that didn't happen, and I think as Attorney Smith pointed out, were the board to then issue a written finding stating, based on the failure to obtain the requisite number of votes, this is a deemed denial, that would be an appealable decision. And I think regardless of whether that written finding was ultimately produced,
Well, it
there's
wouldn't be appealable yet because it was only about the boundary extension, right? They'd have to vote on the project as a whole, up or down, with sufficient findings for it to be reviewable, for it to be an appealable final decision, right?
Correct. So there'd be 2 ways really for the applicant in that circumstance. And again, this is all just a large hypothetical, but there would be 2 ways for the applicant to ultimately obtain either appealable decision or just bring it straight to court in an ADB, which would be either to assert that there was a failure to act by the board in failing to provide a final written decision, and you could submit that, or to request that the board actually submit or prepare a final written decision clarifying that its action was final, either of which I think would be sufficient in the context of an ADB appeal to demonstrate the finality of the board's actions there.
Well, can you talk a little bit about this issue that we've discussed about prejudice, and what kind of prejudice then would the appellant need to show in order for him to prevail on appeal?
I think you'd need to show something more than has been shown here. I mean, here there's really no statement of prejudice. There's simply an assertion that, this was a motion to reconsider, this was an issue under reconsideration, and had I been afforded the opportunity to speak, I would have said something. And it's unclear what that would have been, as the only comment that the board received was really related to an issue that's entirely unrelated to the boundary line extension. It was related to the traffic analysis and the traffic impact study. And any public hearing specifically related to the request for reconsideration or the motion for reconsideration would have been limited to that subsidiary motion, which doesn't really
Does the
pertain to
appellant have to identify on appeal a criterion that he believes hasn't been met, so the plan should not have been approved for that particular substantive issue in order to have, show the prejudice he needs to for an ADB appeal?
So I believe that this court's holdings in Jackson and Anderson indicate that there has to be some reasonable statement as to the prejudicial impact and a merits-based criteria or a merits-based error. If the, denial of due process was somebody arbitrarily shutting a door and physically preventing someone from getting into a public hearing, that alone might rise to the level of a due process violation that gives a separate right of appeal.
So he
Where-
seems to be saying that he was so confused by what happened in the March hearing that he never appears for, that he was totally surprised when there was then a continuation to then review the plan as a whole. And because that was surprising, there should have been more notice to him. What's your response to that?
My response to that is that had he reviewed I don't know if he reviewed the meeting video or anything, but it was very clearly stated on the record by the board chair that no action had been taken and that this application was being continued to the next meeting. There was no final action taken, either with respect to the boundary line extension or the ultimate approval, which is, the source of the contest here, the desire to have this not ultimately be approved. So I think where there's some type of error or misunderstanding on the part of the appellant, that doesn't give rise to an independent duty on the part of the town to provide some type of individualized notice or something like that. The town adopts procedures that are applicable to all of the hearings before the planning board and lays out the process that it deems adequate and necessary for, to receive informed public opinion and allow people to state their, to provide comment and speak intelligently about a project, but they're not entitled just because of a misunderstanding or a willful neglect to review the board's procedures or the board's meetings to claim that they're entitled to further process.
Could the board have opened the April 11 meeting up for public comment if it wanted to?
If the board had been so inclined, they could have, and I believe the court's holdings in, Deneen and Cunningham indicate that, the board has the authority to do that, and although the public has a right to be able to provide comment in opposition or in favor of a project, ultimately that has to be balanced against the efficient administration of the board's review. So it would have been within the board's discretion, but I don't think there was any request made to reopen the issue for public comment at that point, so there was no action that needed to be taken by the board on that, and they were well within their discretion to continue with their deliberation and review of the project and the subsidiary motion on the boundary line extension. But ultimately, I don't think there was any need for reconsideration here. I think the board abided by all of the processes laid out in the Code of Ordinances and its bylaws, and to the extent there was any procedural harm or any procedural error, even that hasn't amounted to any prejudice or fundamental unfairness to the appellant here. So I think the appeal should ultimately be denied.
Thank you.
Thank you.
And Attorney Brandwein, I believe you have 3 minutes for rebuttal.
I do. Thank you. Your Honors, Section 17 of the bylaws exists to impose process on the board to ensure that board decisions have finality, which is a fairly common policy, an important policy concept in both municipal law and this court's own jurisprudence. The vote on March 28th was a vote within the meaning of Section 17. Section 17 says, when a vote is passed, it is in order for a member on the prevailing side to move reconsideration.
Well, the question is, what is passed?
That is the question in this case, Your Honor. I think that's the core question.
How can it pass when Section 7 says all decisions must
Passed-
be made by a minimum of 4?
You're reading, Your Honor, respectively, passed as approved. Passed does not mean approved in this context. Passed means occurred or happened, which is a
Well,
fairly common definition of the word passed.
Let's say that 3 members had voted in favor and there were no votes against it. It didn't pass, but it can't be reconsidered because there were no votes in the opposition. Is that?
Final decision. Final
that's the
appealable
bottom
decision.
line?
Yes, that's final appealable decision. The language in Section 16, decision, that's describing a category or type of vote being broader than decision. Section 16 is describing a category of vote that requires 4 affirmative or like votes to be approved. The motion on the table on March 28th was a motion to approve the extension of the C3 zone. That needed 4 votes. to be approved. It didn't receive 4 votes. There is a final outcome susceptible of both appeal to this court and of reconsideration by the planning board under Section 17 of its own bylaws.
It wasn't a vote on the plan, it was a vote on the boundary extension.
That's correct. But as I think you heard was admitted, the plan as written couldn't pass unless the boundary line extension was approved.
And you've identified nothing about the plan that doesn't meet site plan review.
The prejudice, Your Honor, is the failure of the board to follow the procedural safeguards laid out in its own bylaws.
And
Those,
do you agree with me that you have identified and cannot identify no other prejudice?
I don't believe that's required. What's required is a showing
And
that.
if we disagree with you? We lose.
So
I do disagree, Your Honor.
If I can just ask you, so when you read Section 17, you say when a vote is passed, that can be a vote in the negative or the affirmative to whatever the proposition is?
That is a vote that has occurred, Your Honor. A vote
Okay,
that
so
has
you're saying a
happened.
vote has been completed, that's what passed means
Yes,
there?
that is correct.
I'm just going to say that I think a casual reading might say when a vote is passed, it represents an affirmative finding and approval of the proposition?
I think that's incorrect, especially when you consider Section 17 as a whole. Section 17 says a member of the prevailing side may move
So who's the prevailing
reconsideration.
side in that circumstance if it's 3-1-1?
Prevailing side is outcome neutral. The prevailing side, when a motion is approved, are the members who voted in favor. Prevailing side, when a motion is not approved, are the members who voted against.
Thank you.
Thank you. Appreciate the court's time.
Thank you, counsel. As is our usual practice, we'll be taking the matter under advisement, issuing a decision in writing in due course. With that, we're in recess on this matter.
All rise.
Good afternoon, you can be seated. And the matter before the court is McCallion versus the Town of Bar Harbor et al. On both sides. This is Hancock 24-365. We are being streamed on the web, both by video and by audio. If counsel who are arguing would identify themselves by saying their names for the record, please, together with the parties that you represent, starting with the appellant.
Yes, good afternoon, Your Honors. This is Colin Chard for Monica McCallion, Brandon McCallion, and Old Bears LLC.
You?
Good afternoon, Your Honor. Jonathan Hunter for the Town of Bar Harbor.
Thank you. And Attorney Chard, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. And may it please the court. I think I'd like to start off emphasizing that we are construing a statute here that concern the continuation of a non-conforming use and the concern limitation.
Counsel, I see that the green light is on. My understand, these are, have to be renewed every year, right? Or re-granted. I mean, that's part of the issue.
Yes, Your
right?
Honor.
This was 2023 that we're talking about.
Yes, Your Honor.
In this appeal. My understanding is that in 2024, it was renewed, and that is a final decision, no appeal was taken. Is that accurate?
Yes, Your Honor.
Is that information we can consider?
Yes, I believe that was noticed in the Superior Court, Your Honor,
Okay.
although it was not a matter of fact that has ever been heard.
Nobody seems to have contested it, I've noted.
Right, and I think that it's not material to the ultimate relief that we're seeking here.
Well, isn't it though? Because if he has a permit for 2024, wouldn't necessarily the application for 2025 be a renewal? And you can argue anew whether it should be renewed, but wouldn't the application for 2025 by definition then be a renewal?
Yes, it would be a renewal, and I would, if I may, Your Honor, just ask the court to please take under advisement my motion for this court to take judicial notice of the addendum to Warm Management LLC's addendum that was filed.
I.e. that you've appealed the 2025?
Yes, Your
Is that what
Honor.
we're talking about? Okay.
And this is important because, at a minimum, as set forth in the papers which were received without objection and that I've sought judicial notice to be taken, the one basis for that application for administrative appeal in the town of Bar Harbor is that they continue to operate in a manner that is in, quote unquote, in violation of the ordinance governing.
Well, the 2024 decision is final, correct? The administrative decision.
Well,
It wasn't appealed, it's final.
right,
Correct?
Judge, I think there is a little more nuance to that, if I may be heard.
Proceed.
Yes, thank you. Okay, so the appellees have raised issues concerning collateral estoppel in their papers before this court. And this is important to talk about. I think this is very important to talk about because this brings us to sort of some interesting issues concerning due process. And I will, if you'll bear with me, the statute that's cited in favor of the proposition that unappealed, in this instance, the 2024 appeal, where not appealed, it is subject to principles of res judicata as established by law. There is a host of case law in the state of Maine concerning whether and when what I believe the court is referring to as an issue preclusion. variety.
I'm going to stop you there, because isn't the significance of the 23 versus 24, it's really not an issue of issue preclusion, res judicata, or anything collateral estoppel. It's that it's moot, because the 23 is no longer in effect. He got a renewal in 24. You can argue whatever you want on your appeal at this point. I mean, we're certainly not deciding what you can argue or the scope of any appeal on the 25 permit.
Yes.
But isn't the 23 permit moot, because it's essentially been superseded by all of the other proceedings?
And just to put the proper spin on it, it's lost its vitality. It really doesn't matter at this point because 2024 is there. We can't unwind 2024, so the issue may have something to talk about on the 2025 appeal of not following the proper procedures, but 2024 is there. It exists. It's a final decision, hasn't been appealed. So hasn't the 2023 appeal lost its vitality? What could we possibly give anybody or take away from anybody regarding the 2023 year?
It's my position, Your Honor, that I would say it's a close call as to whether it is technically moot or not. I think there's some overlap between the sort of the technical mootness of this appeal versus, there's overlap with one of two exceptions to the mootness doctrine that apply to this case. And I think the first exception to the moot, setting aside the res judicata and due process issues, the first exception is the, well, first, I think that the relief that we're seeking, which is an interpretation of the statute, which the town has never done, and a
But
final...
we don't give advisory opinions in appeals.
Yes, Your Honor, okay then, but it's not advisory if there are sufficient collateral consequences that flow from...
What would be the collateral consequences?
The collateral consequences here are that this court should interpret, according to the plain language of the land use ordinance, that the term in violation does not refer to notices of violation, but rather refers...
That's not a consequence. You're asking us to issue a decision.
But may I just explain how that has its collateral
Please.
consequences?
Please.
Okay, thank you. This court should explain the plain language definition of the term in violation as it's used in the land use ordinance. It will have to be applied in the 2025 appeal where, as I've alleged here, there will be the collateral consequence that the town will be required to apply the proper interpretation of that provision.
Well, isn't that just an advisory? You're asking us to tell the town, going forward, this is the interpretation of the statute you should use. But if we were to adopt that interpretation, what effect does that have on the 2023 permit's dead, right? I mean, it's expired by its terms. It's been supplanted by 2024 and now 2025, correct?
Well, it was dead on May 31st before it was ever renewed, Your Honor. But I think what you're asking me is, Attorney Chard, what is the collateral consequence, the sufficient collateral consequence?
Right.
Which is an exception to the mootness doctrine.
Right, and you're saying that the collateral consequence is an interpretation of the statute that the town can use going forward? Is that the argument? I don't understand.
There are multiple collateral consequences. One of them, I think probably the most important collateral consequence is where that permit is determined under proper analysis to have never been properly issued in the first instance. Then it will have broken the chain of continuous non-conforming use.
But if that argument were to be successful, wouldn't we have to then review the 2024 permit as well? I mean, if that were still a live issue, you might have a point, but the 2024 permit's final. We can't do anything about that at this point, correct?
No, there can be nothing done about the 2024 permit, but if the plain language of the statute states that it must be renewed each and every year, the 2023 failure, right, where this appeal should have been granted below, breaks the chain of continuous.
Except that by not keeping it, there's a chain that you didn't keep alive by not appealing the 24 permit. In other words, that is now settled. And so in 2024, there was a valid permit, which means that the 23 permit, whether or not it should have been issued, now can have no, for us to opine on that, has no consequence because the 2024 permit was in fact issued and final. Had it been appealed, it would be different. And that's why you may, the capable of evading review, for example, or collateral consequences can come up on a yearly permit, but you do have to basically keep the issue alive by appealing each year.
Yes, I understand, Your Honor. And I think what you're saying to me, and I'm not sure that I agree with that analysis 100%, is we're back to the collateral estoppel. I've heard several times, 2024 is final, cannot be appealed, right? There's been a determination, actually, a factual determination on that permit that it had been renewed every year, right? And the town's argument is, well, now you're collaterally stopped in 2025 from saying that it was not renewed every year because of res judicata issue preclusion.
Yeah, but the 25 is not in front of us.
Yes, Your Honor, I understand that. But the point is, I'll try to spit it out. All right? I'll try to spit it out. The cart's before the horse. This court has adopted restatement second judgments analysis as to whether principles of collateral estoppel can apply. On a very basic level, notice and opportunity of hearing, all right, are the bedrock, along with some other factors to be considered. What constitutes notice? Look at the timing of how this happened. Appeal was denied January 22nd, new permit issued January 24th. Was there notice as adopted by Maine? If you please look at Section 2, Restatement of Judgments.
I'm sorry, you're arguing that there's a due process problem with the finality of the 2024 permit?
I'm saying that we cannot be collaterally stopped in 2025 from arguing that there was a break in the chain because it is not precluded.
But I don't
because
think
there
any
was
of
no
us-
actual notice.
The 2025 permit isn't in front of us. I don't think we could opine on whether or not there was a collateral estoppel issue with regard to the 25 permit.
I agree with you 100% on that, Judge.
So why are you arguing about it?
Because it's sort of like a hearsay exception, right? You can't do it, but in order to analyze the exceptions as against mootness,
Okay, that's collateral consequences, not collateral estoppel.
yes, I agree with that. But it has been raised that we would be collaterally estopped in 2025 from arguing that there was, that it had been, as arguing against the factual finding in 2024 that it had been renewed annually, which itself is erroneous.
Thank you.
So, I'm doing my best to sort of
Thank you, counsel. You'll have some time for rebuttal. I appreciate it.
Oh, am I out of time? Thank you.
You are. Thank you. And Attorney Hunter, you wish to be heard.
Thank you, Your Honor. May it please the court. Appellant's argument in this case is essentially that their neighbors should forever lose their right to use their property, to rent out their property, not because of any fault on their part, but because of a mistake made by the town. We don't believe that's the law or that should be the law. We think that when a government official makes a mistake, they should correct the mistake, and they have a responsibility to do that and the authority to do that. We also would like to point out that the appellants here are essentially trying to turn what is a ministerial process of renewing a permit every year into sort of a end run around the normal process by which land use violations are investigated and enforced. You know, ordinarily the CEO would investigate, determine whether or not there is a violation. If she determined that there was, she would issue a notice of violation and give the landowner an opportunity to cure that. What is being requested here is that sort of the Board of Appeals or the courts determined in the first instance that there was some kind of violation, never found by the code enforcement officer, and then permanently deprive Warm Management of their ability to renew their permit based on something that they had no notice of or opportunity to correct. And again, we don't think that's the law. I understand the court has already tread on the mootness issue, so I will waive the rest of my protected time and happy to answer the court's questions.
Well, then, can we look at the decision by the town from the Board of Appeals? There's nothing in there about whether the plaintiffs, McCallion, met the appropriate requirements for a renewal. I mean, there's no findings about that. Isn't it a de novo proceeding?
It is de novo. The Board of Appeals found that that Warm Management did everything they needed to do in order to get the permit. They submitted a timely application and fee, actually 5 months before the deadline, and the permit would have issued, but for this failure in their
Well, that's what they
online
said,
system.
but you seem to, and I guess maybe this is a question, for a renewal, forget the timing issue and the fact that the computer wasn't working right, bane of many of our existences these days. Let's assume none of that had happened, the renewal issued, and the plaintiffs in this case were contesting that they didn't meet the requirements for renewal. And looking at the ordinance, I mean, it does talk about, where is it? If the dwelling unit has met all requirements, shall issue a registration in 174-7E, issue the registration if the dwelling unit has met all the requirements of this chapter.
That's correct.
Do you agree that that governs?
It does govern. It's-
Okay.
yep.
So they're contending that, in fact, this, you may disagree, but they are contending that, in fact, this unit did not meet all the requirements of this chapter, right? I mean, that's their position.
That is their position.
And are there any findings in the decision from the Board of Appeals as to whether this dwelling meets the requirements of this chapter?
I believe there are, in the sense that the board found that they were entitled to the permit. And I just,
So that's, I mean, we have a lot of decisions on what are adequate findings for review.
right.
And, I mean, we've clearly said it's not enough to just issue it and say you can have it.
I think the confusion, and, you know, this is a registration statute that's sort of layered on top of the land use ordinance, is that there's requirements for registration, and then there's requirements for, you know, operating. 174-5, those are the requirements to operate short-term rentals. Those, that in subsection A says that STRs must comply, parentheses, it cannot be in violation of Chapter 125, which is the land use ordinance.
Right.
So they do, you know, you see in some cases there's confusion about there's two ordinances, does one displace the other, or do you apply both of them? This makes clear that they still have to comply with the land use ordinance. 174-7 is the requirements for renewal of a registration. And for that, I think all that's required, Your Honor, and what I would submit is, all that's required is that you submit an application, you pay the fee, and there are no pending notices of violation, no
Can I ask-
outstanding.
But you're layering an interpretation on there that there's no pending notices. And there's nothing in the decision from the planning board or the Board of Appeals that goes into that.
I agree that it's not as perhaps precise as it could have been.
Can I ask you about the mootness issue, a couple procedural questions?
Sure.
The fact of the 2024 permit and then the lack of appeal from that permit, that information is not in the administrative record, correct?
Correct.
And so I'm not sure you asked this of us, but we would have to take judicial notice of that on appeal to address the mootness issue. Is that fair?
We asked the business court to take judicial notice
Right.
of it, which it did.
Correct.
To the extent that we have to ask this court to also judicially notice it, I guess I would orally move that. I frankly didn't think
Well, I
once
mean,
it was in the
that's
court
my
record-
question, is it, because we are reviewing sort of the administrative record directly, right? But your contention is that either it's in the record or we should take judicial notice of it, is that right?
Yeah, I think it's.
In other words, that's not part of the the fact that the Superior Court took judicial
Right.
notice still doesn't make it part of the administrative record.
Correct. That information couldn't have been part of the
I
administrative
understand.
record. And I think this court can take judicial notice of it. It's a public document, and I think this court's cases support that.
And then can you address, I think I understand the McCallion's and Old Bear's argument to be that we, even if the 2023 permit is no longer in effect, that if it should not have been issued, that sort of breaks the chain of renewals. And I understand your argument to be that it doesn't matter because 2024 is final, we can't undo that. But where in the ordinance does it say that the renewal is only keyed to the previous year's permit? Why might they not have an argument, and we wouldn't opine on that, but at least a possible argument that if there's any break in the chain, a renewal shouldn't be issued? I think that's their argument.
Yeah. I don't think the ordinance really addresses it either way. I think if you look at the overall scheme, it's not an issue of collateral estoppel or claim preclusion or anything like that. It's simply that there is a 2024 permit. The ordinance says that you can, if you have a valid registration, you can renew it. So that 2024 registration is an independent basis in future years to continue to renew. What happens with 2023 essentially doesn't matter anymore because that right wasn't preserved.
Can I step you back, just stepping over the 2024 issuance and the consequences it has here? Looking at the ordinance here, I'm just wondering if the town has painted itself into a corner by laying out a fairly strict structure. As you know, it provides the code enforcement office shall issue a registration for the property, blah, 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 so on. Registration, then it goes on to define registration. Registration means, in this instance, a written permission issued by the code enforcement officer to property owner to operate a short-term rental. And it requires registration be issued by the CEO before May 31st, or the registration is expired and ineligible for renewal. Obviously, that would give a CEO the prerogative of simply not issuing registration and ending that landowner's future, as an arbitrary decision by the CEO. So it creates a strict compliance obligation on the town and the CEO, but if they fail to do what they're strictly supposed to do, it has profound consequences on the landowner. Do you read it the same way? Is the issuance of a CEO by May 31st the end of the world if it doesn't happen?
Yeah, I think you could interpret it that way. I wouldn't interpret it that way, and frankly, I wouldn't want to be in front of this court defending it if it were being enforced that way. I think if it were enforced that way, it has some serious notice and due process concerns and arbitrariness concerns.
An equitable estoppel against the town concerns, and it's a ministerial act, and the act is mandatory.
Yes, and I think the court in the Auburn case said that equitable concerns can be a bar to enforcement action.
There don't appear to be additional questions.
Thank you, Your Honor.
Attorney Chard, I believe you reserve 3 minutes for rebuttal.
Thank you, Your Honor.
I'm going to have to continue to take issue with how the town has characterized the nature of this action. It's not that it was a violation was never found. There was an explicit finding on the permit renewal paperwork that no violations existed. And the very subtle differences in those words, which have continued to come from the town, well, no violations were found to have existed. There was an explicit finding that no violations existed. And that is what is under appeal here. as far as no fault, I'm not sure that we're entering into sort of equitable considerations here. I believe those were probably waived for not having been brought before the Superior Court. But as far as fault is concerned, I guess I would segue that into Bradbury Memorial and say again, if it is May 20th and you have received one of your 2 VR2 registration renewals, which you have renewed continuously over the last 8 or 9 years, and of which you are well aware of the consequences of not doing it.
Doesn't your interpretation, though, I mean, it works a very harsh result. So the ordinance doesn't give a deadline to apply. It just says has to be renewed by May 31st. So couldn't a reasonable VR2 owner, send in an application on May 31st? What if the town doesn't have, in your view, if the town doesn't have time to act on it, they're out of luck?
Well, in my view, perhaps there may be something implicit there that, okay, they're going to be reviewed before May 31st. But this utterly, calling the timing of it a red herring, notwithstanding that we're strictly construing a statute that requires strict compliance. Notwithstanding that, all right, let's set aside the red herring of the timing. It did not meet the standards for approval. There were outstanding violations. And which brings me back to the relief. Should this be remanded, right? I say the decision of the board was utterly devoid of findings and is inadequate as a matter of law, and the permit should be denied. But should this need to go back to that board for consideration, I think that board could use some guidance as to exactly what the term in violation means. Because there are explicit findings, written findings that are on appeal here, that there were no violations. And I would circle it back to Bradbury Memorial, though, Your Honor, where if we are to consider the timeline directory, it is directory for the purpose of allowing the applicant, as in Bradbury, to knock on the door, right, after a deadline has gone by.
Thank you, counsel. And your deadline, I'm afraid, has gone by as well. The red light is on.
Thank you.
That just seemed like the right phrase to end it on. Counsel, thank you for your argument here this afternoon. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in the normal course. Thank you.
All rise.
Good afternoon, you can be seated. The matter before the court now is State of Maine versus Damion Butterfield. This is Cumberland 24-282. I see counsel are present, I'm assuming ready. We are being streamed live on the web, both by audio and by video. If counsel would introduce yourselves by saying your names for the record, together with the party you represent, starting with counsel for appellant.
Good afternoon, Your Honor. I'm Jim Hawanik. I represent the appellant.
Leanne Robin for the State of Maine.
Thank you. And Attorney Hawanik, if you're ready to proceed, we'd be happy to hear your argument this afternoon.
Thank you, Your Honor. Good afternoon, Chief Justice Stanfill, members of the law court. Courts across the country are reanalyzing derivative liability because it is resulting in consequences like that which happened here. A young, profoundly mentally disturbed young man with tattoos across his face, taken advantage of by 3 older career criminals, who was in the wrong place at the wrong time, was wrongfully convicted of murder. In some states, defendants are ending up on death row because they were in the wrong place at the wrong time. It should not be a low burden for the state to establish accomplice liability. It should be a high burden, consistent with our bedrock principles of presumption of innocence and proof beyond a reasonable doubt. Justice Kennedy's rulings effectively concluded that mere presence at the scene of the crime generated accomplice liability. She made no findings of Damion's involvement in aiding in the crime because there was no such evidence. The state's entire case, 100% of its presentation of evidence, was that Damion was the principal shooter. The trial justice further concluded, arbitrarily, that the state should be rewarded with an accomplice liability instruction because the state was sanctioned for an egregious Brady violation, and that an acquittal was now going to result, and that it should therefore receive now a new theory of liability to work with. That was all done at 7 o'clock the night before closing arguments in a murder trial. We were literally in our pajamas watching Netflix. If this court believes that's fair, and that's the way we should be litigating murder trials or any trials in the state of Maine, then it's your prerogative, and you'll affirm this conviction. I don't want any part of it. And we're not going to participate in trials that result in such unfair injustice. This case was not fair, and this conviction should be overturned. I'll take questions, Your Honor.
Counsel, you are before us on an appeal of a plea of guilty, right?
Correct.
And in fact, I think at some point during one of the Rule 11s, it was even said to him, if you enter a plea of guilty, you won't be able to appeal these issues.
Correct.
How can we reach these issues when the plea stands?
And of course, that's what Justice Kennedy ultimately ruled in her order, that when she denied Mr. Butterfield's efforts to withdraw the plea, she could therefore not grant a new trial. And our argument, Your Honor, is that this case was so tainted, so polluted, so poisoned, that it resulted in a due process violation, and that this is a factor that can be considered. I think it's under the 4th consideration in the Hillman case, the deficiency of the proceeding at which the defendant entered the Rule 11 plea. This was a Rule 11 that resulted from about 20 minutes of deliberations with a mentally disabled young man as a verdict was coming in.
But there were two Rule 11s, right? The first one came in and he didn't like one of the terms, and they recessed and rejiggered it? And
No, Justice Kennedy, to her credit, I asked Justice Kennedy, I said, if we're going to do this, this was all done against the advice of counsel. We put that on the record. To her credit, Justice Kennedy accepted my request to have a first Rule 11 in chambers. We brought Damion right into chambers, and she looked him across the desk 6 feet away, and then she went out into the courtroom and did a Rule 11. I look at the pictures from it, and my face was all red when it was happening because this was such an injustice to us.
But this was an extensive Rule 11. I mean, she really covered all the bases, went back and forth, and asked him, and he goes, absolutely. This is, I mean, on the face of it, it is exemplary plus for Rule 11s.
It was, except that it was happening as a verdict was coming in. The jurors, over the course of 3 days of deliberations, brought in, I think, about 6 or 7 or maybe 8 notes, all of them associated with accomplice liability. And by that 8th note, it was clear that they were going to find him guilty. They asked something like...
But we don't know that, counsel. I mean, wasn't this ultimately a strategic decision on the part of your client? He didn't feel that the trial was going well for him, and so he decided to cut his losses and take the state's offer.
Well, the trial was going very well for us until 7 o'clock the night before closing arguments. We turned down a 20-year offer.
And you're raising some good issues, but don't they have to be raised after a verdict as opposed to on appeal of a guilty plea?
If that's this court's position, which I think was the court's previous position in the case cited by, I think it was the Cody case, I believe, cited by by Judge Kennedy, then you're correct. We'll come back a year from now and litigate this after the post-conviction review. But our position is that this plea was just so tainted, so fundamentally tainted.
Is there something you can point to on the record other than what you're saying there are errors? Let's assume I accept that. There's errors in the way in which the trial was conducted. Assuming I accept that, is there something in which, on the record, that would show us that this was a deficient Rule 11, that it was a coerced plea?
If you take all of the totality of the circumstances, and again, we cited your opinion, a concurring opinion in a case about working after hours. The fact that the entire case was thrown 180 degrees into the opposite direction at 7 o'clock the night before, that poisoned the whole process, including the Rule 11 ultimately.
But I guess, counsel, I have concerns. If I understand your argument, it's that to decide whether the plea was coerced, we need to look at all of the conduct of the trial and determine whether there were errors. So isn't that really sort of a way of backdooring the trial errors that are really typically unreviewable on a guilty plea?
Well, it is a chicken and egg problem, and I think really, again, the only way that we can do it is if the court finds that there was such a deficiency in the proceedings in the Rule 11 to allow him to withdraw the plea. Obviously, as we sit here, I don't know how many times you've seen this. I've never seen it in 40 years where a person pleads guilty as literally we get word that the verdict has come in. And as over at the Cumberland County Courthouse, there's a verdict sitting there in an envelope. That's doing a plea under duress. Put aside all the fact that this is a mentally...
But isn't it always under duress at that point? I mean, during the course of a trial, there's a lot at stake. This is a serious case. There's a lot at stake. There aren't good decisions to be made for your client at that point. And in fact, the sentence in this case was done as an agreed sentence of 35 years for both murder as well as an attempted aggravated murder, illegal possession of a firearm, and the robbery. 35 years, which is not a big sentence based on the facts.
We would have taken the state's offer of 20 when we negotiated this. After the evidence was in, Justice Cole came in and did an impromptu settlement conference. This was on the Friday after the evidence was, or Thursday, after the evidence was in, before we did the Friday morning closings. Then we go home at 7 o'clock, and we're realizing, holy cow, we're dealing with accomplice liability now, when all of the evidence, 500 hours I put into this case, over 2 years, defending Damion as the principal shooter here.
So is that the tipping point, is the fact that the accomplice liability instruction went in the day before? Is that, you keep saying it's tainted, it's unfair, it's this, is that the thing you're pointing to?
Absolutely. It's, because we're now,
So what's the judge to do? The judge makes a decision that I'm going to give an accomplice liability instruction, and actually, I'll suggest there were some reasons to support that, but putting that aside for the moment, the jury announces a verdict, your client says, I want to plead guilty. What's the judge supposed to do there?
the judge is not supposed to instruct accomplice liability. The judge is supposed to.
I know what she did.
I know she did, and at that point, you know, we came the next morning and we made our closing arguments. Neither the prosecutor nor the defense mentioned the words accomplice liability in closing.
If we, not to interrupt you, but if we decide that the accomplice liability instruction was proper, raised, justified, and properly delivered, did the rest of your...
Well, that's the end of the, yeah, that's clearly the end of the argument. Our whole case is about this 7 o'clock at night, changing the entire case from, they're saying that Damion shot Darrell, and they're saying you can still find him guilty even if he didn't shoot him. And that's a theory that we didn't hear about until the night before closings.
Did you ask for a continuance or an opportunity to reopen or anything like that?
I knew you were going to ask that. And, you know, that's easy to say now. We came the next morning, and the courtroom was full, and we're ready to make our closing arguments. I'll be perfectly honest with you, we were hoping to just get away from accomplice liability. We were hoping that, and sure enough, both the prosecution and defense, neither one of us mentioned it in our closings, because I didn't want to focus on it.
Your case was, other guys were there, you know, no one, and the victim who survived doesn't know who fired the shot. Wasn't it the defense that raised the whole question about whether or not he pulled the trigger?
That's a good question. Is that all it takes to establish an instruction of accomplice liability? Is the burden that low, that mere presence?
State's going to say yes.
Because mere presence doesn't, right? I mean, the court's held that mere presence isn't enough. But what else in this record indicates that anything other than that Damion was standing there, that he was merely present? And that really flies again. And that's why Judge Kennedy said not once but twice that accomplice liability had not been generated, that we left the courthouse that day under the impression that it wasn't generated. And now it's like, you know, I'm watching TV and I've got a, you know, I had my sweatpants on and I'm, you know, and I'm like, what? I got to argue accomplice liability now? And at 8:30 tomorrow morning? It's so unfair. It was just and it's not about winning. Of course, everyone wants to win a murder acquittal, but this kid did not fire the gun, okay? And that was clear. And throughout the trial, and they're sitting here, the Portland PD did a great job, including finding exculpatory evidence.
Thank you, counsel. Attorney Robin?
Thank you, Chief Justice Stanville, Associate Justices, may it please the court. This case should not even be before you. Damion Butterfield, the defendant with his gang affiliation tattooed all over his face, pled guilty to murder for a highly discounted sentence after 5 days of testimony and jury deliberations that spilled over to a third day. He pled guilty knowing that the jury was knocking at the door, ready to return its verdict. He admitted during the Rule 11 that he shot Darrell Coffin, who was unarmed and outnumbered, during a botched drug robbery. The only motivation for taking Darrell Coffin's life was gaining street cred. He went on to brag about the crime, telling one acquaintance that if he were convicted of the crime of killing Darrell Coffin, he would tattoo a coffin on his back. Rather than hearing the jury's verdict, he short-circuited the process by agreeing to a 35-year sentence. Under this court's precedent, he has no basis to appeal the constitutionality or propriety of a sentence on a negotiated plea. He went through not just one, but 2 detailed Rule 11s. After having had not just his day in court,
but multiple days in court, and affirming to the trial court that he was pleading guilty to murder because he was, in fact, guilty. It would be a miscarriage of justice to overturn the trial court's decision refusing his request to withdraw his plea. And I'm happy to take questions.
Is that the only issue before us on appeal, really? That whether the court erred in denying the motion to withdraw the plea?
That really is the only issue on appeal, Your Honor, in terms of the alleged coercion or whatever that the appellant raises today. That would be a post-conviction issue. But this was a tactical decision by a defendant who was very familiar with the criminal justice process, advised by not one but 3 defense attorneys about his rights over a period of a day. He made this plea knowingly, and he knew that this was the best deal he was going to get. And the state, and in consultation with the family of the victims, basically recommended the sentence because this would be the end. It should have been the end. But here we are arguing about whether he could withdraw the plea that he made knowingly and voluntarily after 2 Rule 11s.
So, counsel, can I ask you about that then? Because I think you just said the coercion issue, whether the plea was coerced, could be considered in a PCR. But in considering a motion to withdraw a plea, the 4th factor is whether the Rule 11 was deficient or not. So part of that is an examination of the voluntariness of the plea, correct?
Well, there was no deficiency in this Rule 11. There's nothing on the face of this record that shows any deficiency in Rule 11. And the allegations of coercion are the self-serving allegations made by counsel without any support at all.
So that's my question, is how far can we go? What do we look at in determining whether there was a deficiency in the Rule 11? Is it strictly the confines of the Rule 11 itself, or can we look sort of at the broader context of what was happening with the defendant in the case as opposing counsel has argued?
Well, I think as Your Honor noted, that would be a backdoor way of getting into the errors of trial. We have no verdict that we are reviewing. We're not looking at whether or not there were deficient jury instructions that led to a verdict that was unfair. This was gamesmanship by the defense. This was pleading guilty to avoid a more significant sanction after a verdict. The jury was ready to deliver that verdict. I mean, we were ready to get that verdict. And it was only because of the finality and the certainty of a plea of guilty that the state ultimately agreed to this plea agreement for 35 years.
But as we look at the voluntariness issue, can't we look at the attendant circumstances, what was going on at the time, as opposed to simply the defendant saying yes, yes, yes? Can we look at the attendant circumstances?
Well, I think, not based on this court's precedent. You look at the Rule 11 proceeding itself. You look at the record.
Right.
Because if you're looking at other attendant circumstances, what's going on when defense counsel are advising their client in the back room, that's all post-conviction type stuff. That's not really available for the court. And this court's precedent has always looked at the actual on-the-record Rule 11 proceeding to see whether that actually complied with the process. I mean, this is a defendant who said, I want to plead guilty. And I don't want to risk I don't want to throw the dice and see what happens with this verdict.
As I understand Attorney Hwanek's argument was that the trial had a certain momentum, it had a certain vector, certain trajectory, and all of a sudden, it was a sea change the night before, and that sea change was so profound that it undercut the voluntariness of the Rule 11 plea. Your response?
Not all of us were watching Netflix the night before closing arguments. A trial is, I've always said a trial is a marathon, not a sprint. There are ups and downs during trials. There are times that it's like, oh my God, everything's going great, and oh my God, we're going to lose. And it's not all about winning. It should be a search for justice. And this trial was not a search for justice. This was a bit of a game of gotcha, and this was also a bunch of gamesmanship. And this is the final game, and this court should say no to it.
Do you agree there was a sea change in the momentum, the trajectory the night before when the accomplice liability instruction was noted?
No, Your Honor, I do not.
Okay.
It was accomplice liability was a theory that was a concept that came out in the defense opening argument. Johnny Geisinger's DNA was on the gun. My client didn't shoot the gun, even though the only eyewitness who testified and could recognize the shooter said it was Damion Butterfield who shot the gun. So the sea change to us, actually, I can tell you when the sea change happened for the state. The sea change happened for the state when the court excluded those jail calls in which Damion Butterfield made multiple admissions implicating himself as the shooter. And before that, it wasn't going to be necessary to have an accomplice liability instruction because he himself implicated himself as the shooter.
Were there any other facts of record to support an accomplice liability instruction other than his presence with 3 other people?
Well, yes, there was communications back and forth in the car that he was in. They were conspiring with Bear Osborne, who was in the Range Rover with the victims of the crime, and he was communicating with the members of the Honda Element, including Damion Butterfield, about where this drug hit was going to be. And so it was communications back and forth between someone who was with the victims and Damion Butterfield, Johnny Geisinger, and Tom McDonald, who were in the Honda Element, who drove the Honda Element over there to try to steal drugs from Derry Coffin. And instead, it was a drug robbery gone wrong with Damion Butterfield pulling out that gun and shooting Daryl Coffin and attempting to murder Annabelle Harnett.
Counsel, can I ask you about the prejudice to the state prong of the analysis on the motion to withdraw a plea? I certainly understand your argument that it would be an enormous use of resources to retry this, and of course, extremely difficult for the victims' families. But as I read our case law, what we're primarily focused on is whether it would make it more difficult for the state to prove its case if the plea is allowed to be withdrawn. Did you make any argument in that regard below, or did the trial court, I guess more importantly, make any findings that a retrial would be more difficult based on the circumstances here?
I believe the trial court explicitly made the findings that there was not prejudice to the state, but we believe that this court in the Wayland case, in fact, found that the impact on the victims is a consideration in determining prejudice to the state. And here we had a very fragile victim who was, at the time of this attempted murder, a drug addict on the street, who was now 18 months sober when she testified at trial, a very fragile victim, who was on the stand for like a day. And she under significant cross-examination, and she had to travel to the trial. She had relocated to California after this had happened. I believe she's now still out of state. A retrial means the efforts, which may or may not be as successful, at getting all the witnesses back to trial. This is an older case now, and it involved a number of witnesses who were involved in drug use and drug trafficking, and they're not always around.
So is your argument that the trial court's factual findings with regard to prejudice were clear error?
I don't think, I didn't want to get there because I don't think it matters, but I do believe that under this court's precedent, the impact on the victim is appropriate consideration, and it certainly, I mean, this trial court saw that very vulnerable victim go through the day of testimony and knew that we had to go through the out-of-state subpoena process to bring her back. It would be so unfair for her to have to go through another trial. Mr. Monike talked about unfairness. It would be unfair for her to have to go through another trial when the man who attempted to murder her has already admitted that he attempted to murder her. If there aren't any other questions, I'll sit down. Thank you very much.
Thank you. And Attorney Hwanek, I think you reserve 3 minutes for rebuttal.
I'll strongly object to the argument that there was some sort of communications going on before they came to the scene. Attorney Robin, in her opening statement, said Tom McDonald, he was only looking for drugs. He got much more than he bargained for. And Attorney Bogue cross-examined their star witness, Tom McDonald, And he said, was there any conversation? Not so much. The only real conversation was Bear was supposed to be the plug to get Johnny the drugs he wanted. So where's all the discussion about doing a hit on anybody here? They're just going to go to a party and party with some girls out in Westbrook. And Damion, there's nothing attributed to Damion. There's no text messages, there's no phone calls, there's nothing that indicates Damion was part of any plan, that he was furthering a plan to help Johnny, whose DNA was on the hammer of the gun. Johnny Geisinger, career criminal who's got literally like about 20 felony convictions. His DNA was on the gun. There's no evidence that Damion knew anything about that gun before that night. So put yourself in the shoes of the defense. We have this case for 2 years. We put in 500 hours of work. We hire experts. We go through a 2-week trial. Without any question, we raised doubt about who the principal shooter was. There's no doubt about that. That's why they offered us 20 years after the evidence was in. And then we go home. We're ready to make that argument. And, oh, by the way, even though I've said it twice that it's not an accomplice liability case, I, Justice Kennedy, am telling you that the jury's going to hear about a Don Maycomber drafted instruction that was incorrect. And go to note 3 from the jurors, where they ask about the incorrect portion of accomplice liability that's in the notes that were handed in, the instructions that were handed into the chambers.
But isn't your problem that you're not appealing? It's your appeal of your client, and your client pled guilty, knowing all this? And I'm sure you vigorously explained all this to him, correct?
For about 20 minutes, as it was becoming clear as the notes came in that the jury was headed towards a conviction.
I mean, you're just stuck, right, doing what your client wants to do. That's your job.
Well, yeah, I would argue it's not quite that simple, but that again, if you look at the circumstances of this case, that this was a plea that was done under us. I don't know how else we challenge how else do we challenge the issue of...
Wait for the verdict.
Well, maybe we should have waited for the verdict, and I guess we'll take that up in the PCR hearing. But I think we can not. I think there's a mechanism where this court can, if you're going to just get caught up in the niceties of what needs to happen, then you're right. We have to do this at a PCR. But I think this case was so wildly unfair that the convictions should be reversed. Thank you.
Thank you. Thank you for the arguments here this afternoon, counsel. As is our usual practice, we will be taking the matter under advisement and issuing a written decision. And with that, I believe we're in recess for the day.
All rise. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting in the law court, may hence depart and give their attendance here at 9:50 a.m. tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable court.